Hi, welcome to another Ramos Law verdict breakdown. It's Randy Manning here with Jessica McBryant, regular contributor here because of all the verdicts she's won. And today we are talking about Paglio versus the bad guys. Jessica, if you could break down who was Mary Paglio, what happened to her, and why were we in a courtroom?
Of course. So Mary Paglio was our client, obviously plaintiff, and she was injured in a motor vehicle collision where she was rear-ended, and she was actually the first in line with two cars behind her, and then the person who caused the collision behind those two cars. So he was going so fast that all of these cars ended up hitting her with enough force to cause injury to her, and then he even left the scene of the collision. So from the beginning, he was insured by an insurance company who is notorious for offering zero or very, very minimal amounts below past medical expenses, even forgetting about the other damages that our clients can claim. And so she was very frustrated from the beginning and ultimately had no choice but to take the case to trial.
And my understanding is Ms. Paglio had lingering back and neck issues. Is that correct?
From before? Or
No, from after the crash. And so she was trying the case because she had had still pain in her back for a number of years.
Yeah, a lot of our clients have consistent pain that lasts even after a motor vehicle collision. And they try some treatment in the beginning, and then they get to a point where they have to either live with the pain or they have to go forward with surgeries or something like that. And in this case, the insurance company had minimal limits, and so she was worried about what would happen to her, and at a certain point she had to stop treating because those limits weren't going to cover her treatment. She wasn't sure what to do.
Okay, and explain just quickly, what do you say minimal limits? What do you mean?
In the state of Colorado, drivers are required to carry $25,000 as the lowest. If they have insurance, it has to be at least $25,000. The limits go upwards of $1 million or more.
Okay. And who did you try the case with?
I tried it with Madeline Robbins.
Okay. And I believe it was Maddie's first trial, right?
It was.
Okay. How was that working through, it was your second or third first chair trial. It was Maddie's first trial that she was going to second chair. How was it working through that with Maddie and probably all the nerves and stuff that come up?
It was my second as first chair, so still not a lot of confidence in what I was trying to do, and then also helping her through her first trial. But absolutely loved working with Maddie. Great teammate and ultimately amazing trial lawyer. She's done more since, and it's great to see her in the courtroom and finding her groove with it, and she did great in that trial and was really helpful.
So in this case, there was $25,000. That's the max you could get on it, right?
Yep.
What did the defendant offer before trial?
The most defendant ever offered before trial was $4,000.
$4,000. And the client decided not to accept that, correct?
Correct.
And then we can just get to it. I mean, what was the verdict? I could even read it here. So there was the award. I'll read it for you. It was $68,303 in economic losses, $20,000 in non-economic losses, and $5,000 for impairment, for a total of $93,303. So a couple of things there. If there were $68,000 in economic losses, why were they only offering $4,000?
So there were about $9,000 in past economic losses, and then her doctors recommended future treatment between physical therapy to a surgery. And as to the why, I can't really answer for a Fred Loya insurance company. It's what they do. I can speculate that they do it because a lot of law firms out there aren't willing to show up for their clients and force them to trial and force them to do the right thing. But we here at Ramos Law are.
Yeah. So I had done something somewhat interesting. I was the managing attorney, but I wasn't very involved specifically in the run-up to this case. I knew about it. I knew we were going to go to trial. I wanted to support it. But I didn't help with the opening. I didn't help with anything. But I sat in the jury box, or not the jury box, in the court pews, whatever they call them, for opening, just opening. And all I wrote down was like the 3 or 4 things that I thought we needed to prove. And then I wrote down all of like things that I thought you just needed to wipe away. Like, or no, I wrote down the things they needed to wipe away, like just don't even worry about that. And then like the 3 things they were making points on. I actually thought that was an interesting approach. Did that help you? Do you remember even that happening?
I remember it happening, and it's very helpful because you can kind of have a little personal bias in what you think the important parts are, what you think the jury needs to hear in your own cases, and with meeting with your client, all that. You can get buried in the documents sometimes. So, finding the trees through the forest is very helpful, and it's helpful to have people that don't know a lot about the case listening to an opening, listening to trial if you can't have a shadow juror or something like that in the back, and then giving you information on, I'm confused about this, can you give me more information? Or, oh, they got some points here, what can you do about that?
Yeah, and that was kind of my thinking on it, is I had never done that before, where I was pretty well removed from a case, and I don't think I had any brilliant insight. I think that I just didn't know enough about all of the minutia of the case that I could sit there and just be like, if you're sitting there objectively, I can hear their points and I can hear your points, and here's what we need to stick to. And I think that's a very interesting strategy, is just going forward, is to have somebody who an attorney or even just a bystander, a layperson, just sit there and listen to like what's persuasive and what's not.
Yeah, even if it's a family member or friend that can go sit through trial. And we've had our trial tech company, who we've used for a few trials. The person that sits there and helps with our technology is also someone who gives us some pointers.
Yeah. Well, let's get into these damages. I mean, this is crazy. The defendants, this insurance company, they only think that they should have to pay $4,000. What was the anatomy of the verdict? Like, how did you get them to go, the jury, to completely disregard what the defendant thought the case was worth and to get them to agree on a much higher value?
All I could do was present the evidence we had, which in written form, it was the medical records and through testimony. So called our expert who had treated her for the most part at this clinic that does chiropractic treatment, physical therapy, and some pain management. So she was the doctor who provided her with a couple injections and then said she might need more injections, more therapy, potentially surgery in the future. Called the police officer because they weren't admitting liability, even though it was a rear end collision and he'd fled the scene, which seemed absurd to me, but they do that sometimes. So all you can do is tell your story and believe in it. If you don't believe in it, the jury's going to believe them. Okay.
Now, do you think that, and I don't know if you talked to the jury afterwards or not, but do you think that the fact that the defendant left the scene of the crash, do you think that increased the amount of damages the jury awarded?
I'm not sure. None of them stuck around to talk afterwards, otherwise I would have asked them that. I don't know. And when that testimony came out that he left the scene of the collision, defense counsel, I remember, went up and said he's already been punished for that. He had to do community service.
Okay.
So I was surprised that she said that, since we're not supposed to talk about citations or anything like that. But yeah, I'm not sure. I just think we had an incredible client who was very credible and very believable and very kind. And I think the jury believed her, believed that she was still in pain, even though she had stopped treatment 2.5 years before trial. And they wanted her to get help.
Yeah. Now, I remember going into the trial, or if I recall correctly, and you might just, I might be missing something, but this was one that you were maybe a little bit like, I'm not sure I'm seeing this the same way that you are, that I was. What were your hesitations about the case going into trial? And then we'll fast forward to how you felt when the verdict was read.
I'm not sure if I remember specific hesitations. I remember I felt hesitant after. while I was waiting for deliberations.
Oh, okay.
And I think we had a very young jury, and they were very, very hard to read. And so after closing, I was convinced that we had lost, that we hadn't done enough. Not that we would have gotten 0 on a rear end collision, but I was convinced we maybe, would get her past medical expenses, and that was it.
Yeah.
And I think I have those doubts every single trial. This one was very difficult to figure out where the jury was going to go.
Yeah. Well, and I think attorneys get caught up in, and a lot of, including me, would hesitate. Oh, well, we only have 9,000 in bills, right? Like, how are we going to, what are we going to win here? We're going to win 15 grand, or what are we doing? How was it when you were doing the closing, when we got $9,000 in bills, the client hasn't had medical treatment in a couple years, and then you're probably asked for, I don't know, a couple $100,000. Like, how did you work through that?
Yeah, we asked for a little over 200,000, and you definitely have a little imposter syndrome when you're bringing big numbers on cases like that. And all you got to do is try to believe it. If you can believe it, if you can believe that your client's life has been affected and that they deserve this because of what someone else did to them, then that's all you can do. You just do your best, and hopefully the jury will believe it too.
My understanding is the comment the defendant's attorney made regarding the he's already been punished wasn't the only off-color comment that was made during closing. What else was there?
Unfortunately, true. So our client was white and the defendant was Hispanic, and our client was also in a couple other motor vehicle collisions. And she didn't have lawsuits based on those. She didn't have treatment because of those, because she wasn't injured. And the defense attorney came up in closing and said that she brought this lawsuit because she was racist, which was a shock to me. I think it was a shock to the judge. And I believe it was probably a shock to the jury as well. So I got up in rebuttal closing and said she brought this case because she was injured and because the defendant hasn't made it right.
Yeah, that would be, as somebody who's been called a misogynist in a closing statement, that would even be maybe even a little more shocking. All right, so verdicts read. I mean, how did you feel?
I felt amazing.
Yeah.
I had done a few trials before that, second chair and first chair, and after all of those, I felt like disappointed. Even though we had won, I still felt disappointed in the amount. It wasn't what we had hoped for. It wasn't what the client had hoped for. On this one, even $25,000 would have been incredible for the client, but to get $93,000 in a verdict, which turned into $130,000 in a judgment, the client was ecstatic, way more than she ever hoped for. She was expecting $25,000. As best case scenario, her entire case, she was told 25 is it. And we were able to get way more than that, and it felt awesome.
That's amazing. And so even though the policy limits were only 25,000, the judgment was 130. How's that work? What happens there?
So that is, if you offer the policy limits pre-trial at some point, and they fail to pay it without a reasonable basis, and you go to trial and you get a judgment above the policy limits, they have now exposed their own insured, the defendant, to that excess judgment. So they could say, we'll pay the $25,000, you're on the hook for the rest. But then if they do that, they know that their insured can come after them in a bad faith case later, that you didn't protect me when you had the chance to protect me. And so a lot of insurance companies now know, if you have the ability to settle, you don't do it, they get more than they'll pay. And that's what Fred Loya eventually did in this case.
So in this case, they could have gotten out of this thing for $25,000. Instead, they paid some lawyers probably. They paid all their doctors or whoever else, whatever they had in cost. And then they ended up paying, 4 or 5 times their policy limits roughly. So not a great day for Fred Loya.
Not a great day for Fred Loya. But I think on a cost-benefit analysis, there's not enough people injured by Fred Loya insureds hiring attorneys, and there's not enough attorneys that are taking them to court.
Yeah, that makes sense. And so client's ecstatic. I mean, she's thrilled. Like, what'd she do after the verdict?
She hugged me. She
Oh,
cried.
that's nice.
Yeah, she was so grateful. Still reaches out to me every now and then to say how thankful she was that we were willing to do this on what she felt was a small case. She felt it was insignificant compared to other people that have been injured, and that we were still willing to do it meant a lot to her, and so that meant a lot to me.
Yeah. Well, that's amazing. I mean, great trial, great result. You know, that's awesome. That's going to conclude another Ramos Law verdict breakdown. If you have any questions about this case, you have a similar case, you want any other insights about something we talked about today, feel free to reach out to Randy Manning, Jessica McBrien, and we'll clue you in even more. Thank you for watching, and have a good day.